We just finished with the Lindsay Clancy closing arguments, and I'm creating this video before we even get a verdict. Just about, what I thought going in, what I thought about the closings from each side, and where I think we need to go as a culture, as a society, and definitely we need to improve our healthcare system. And hopefully that's one of the big takeaways of this case. At the start of the day, I started live on Court TV. Started at 9 a.m. and we had the ability to preview the closings. I was live with Ted Rowlands as well as Susan Hendricks. And we were talking about the line that Reddington had to toe. And that was between two things, because the prosecutor still has to prove the murder or manslaughter beyond a reasonable doubt. That is first, even before we get to the mental health defense of disease or defect and no capacity to understand right from wrong or ability to conform conduct. Okay, so he had to do that by holding them to their burden, right? And then also the fallback position of not criminally responsible. That's number one. Number two, there was also varying degrees of murder that had to be addressed, because the first degree was deliberation, and then also the atrocity and cruelty of the murders themselves. Without those elements, it falls down to a second degree murder. And Reddington also was able to get the manslaughter as a lesser included, including the involuntary intoxication defense that the judge did include in his charge. He was arguing that medication could have prevented her from the mens rea of the deliberation or the intent to kill. So that's the three crimes on the menu of verdicts that the jury must first find that the prosecutor proved beyond a reasonable doubt. Then, if the prosecutor proved one of those three beyond a reasonable doubt, then the next question would be, did the prosecutor disprove the disease or defect or the capacity to understand right from wrong? And the prosecutor could disprove either one of them, and it's proof beyond a reasonable doubt. So that is a high burden. As I said on Court TV, in New Jersey, the burden is on the defense to prove that by a preponderance of the evidence. In Massachusetts, it was on the Commonwealth to disprove it beyond a reasonable doubt. And that's where I land. That's where I have been for the last couple of weeks. I've been very, very transparent about that on my posts and my commentary. I don't believe that the Commonwealth disproved the mental defense, specifically Dr. Resnick. Dr. Resnick is definitely one of the biggest world leader in this area of psychosis. And he testified that he was the doctor in Susan Yates, as well as a number of the high profile cases involving mental health defenses. So he brings a tremendous experience and credentials that needed to be disproven by the prosecutor. So even after the closing arguments, I still fall on that. I think that's the appropriate disposition, not criminally responsible. There's also that line that could have been drawn too, saying like they need to prove the murder beyond a reasonable doubt. And I know a lot of people are very critical of Patrick in many different ways, including whether or not Patrick could even hear that Lindsay Clancy said that I tried to kill myself or basement, as the prosecutor and the experts on the Commonwealth side are really relying on to tie in her understanding of right from wrong and the ability to conform her conduct. So that's where I land. Now, the closing arguments were both about 1 hour, Reddington started. Reddington was first. And I'll first talk about Reddington's closing. First of all, Reddington in this case has shown that he is a free, he doesn't go off notes. He's streaming, like thinking and questioning, and he like goes as he goes. So there's not much organization to his line of cross-examination and presentation. And we also saw that, unfortunately, in the closing argument. I felt that it was disorganized. I felt like it was disjointed. And I, as a whole, feel that it was all emotion and not like very like targeted to what the jury needed to tie in and to consider. Specifically was her capacity to understand right from wrong, capacity and her appreciation and the ability to conform her conduct. In fact, I do not believe that Reddington even brought it up or addressed it. He was all about emotion. And he started out the closing arguments much like I would start out, on the burden. As I said on Court TV, leading off the coverage, the burden is the key. This is the key to the closing, is to show them that the burden is all with the Commonwealth, not only on the murder itself, but to disprove the mental health defect, disease, appreciation to conform the conduct, right? So he starts out talking about reasonable doubt. He starts out talking about the constitutional protections. He started out talking about the big bad government. And that was kind of the theme to his closing argument about the government and how the government distorted the facts and the government manipulated their evidence as they went. And the government wasn't consistent with what they promised to do in the opening statements. So he starts out with like the red, white, and blue, as I call it, defense of proof beyond a reasonable doubt. And that's where, he tried to toe the line between holding the burden, holding the state to its burden on the murder itself versus to disprove. And he could have done it a little better. After that, he moves into this Google history and starts to talk about the medications and the research that she did and how she was active in her treatment with journals and Googling. We have the Google search results from the computer as well as her phone that we heard she was Googling the side effects and about the drugs she was taking. And he takes shots at Dr. Tufts and the medications that Tufts administered. So he was going after the doctors in this area as well. So the medications, showing that she's an active participant in the treatment, that she was trying to get help, that she was trying to get back to work, and then goes into this challenge to the doctors and the healthcare system generally. One that was definitely landing throughout the trial in the cross-examination. I will say that I think that this is where the prosecutors made a huge error tactically in the trial, because in their case in chief, they only had to prove the murder, right? So it was the prosecutor's witnesses first and the cross-examination of Reddington. And then Reddington called Zeisel and Resnick and some other witnesses like Patrick's mom. And the form is very important there, because when the prosecutor called Tufts, Dr. Tufts, and the providers, Reddington was after them in cross-examination. And that's where he was able to really build up this challenge about the practitioners and what Tufts didn't do. Tufts didn't see her in person. Tufts didn't get the medical records. Tufts just prescribed these medicines. And Tufts was a telesession the day before the 24th too. So he was able to do that through cross-examination. when they didn't have to call those witnesses then and there. They could have left Reddington, okay? But Reddington did get the opportunity to cross. And this is where I think his cross lands and his closing lands is on the credibility of the treatment providers themselves. And this is where he goes after them. He also talked about, again, the two things that they had to prove beyond a reasonable doubt, that she's guilty of the murder, and then they had to disprove the disease or defect. But one thing that Reddington did not do, and it's right there too, and he just talked about the disease or defect alone without acknowledging the capacity and appreciation for right and wrong. And in fact, when the prosecutor gets up, and I'll get to hers a little more thoroughly at the end, the prosecutor acknowledged and conceded the disease or defect immediately. This is not about a disease or defect. We acknowledge a disease or defect. It's whether or not she understood and appreciated and had the capacity for right and wrong. So that's where I think the closing on the defense side could have zeroed in much more, because that's really the main issue that this jury is going to have to decide. Talked about the investigation, talked about how she was handcuffed in the hospital, said it wasn't those pink furry handcuffs, right? Trying to challenge the way that she was treated at the hospital and how they were trying to get information from her fresh out of surgery. Talked about the anesthesia, that she was paralyzed, that she was in pain, right? Talked about the delirious state that she was in at the hospital, where they're trying to attribute some handwritings or statements in the medical records and through the experts, right? So after that, he went into the challenge of the investigation, talking about the crime scene, how he was the one. He's saying that he went into the house with Zeisel, and he had a bag of medications that he secured, that they didn't seize, that they didn't test. I had that for years, right? He's challenging their investigation, challenging the lack of testing in the residue, challenging the fact that they didn't test the blood in the bedroom, challenge them a lot about Patrick as well. This is a little where the Patrick issues come in. Definitely not what a lot of my followers and commenters on my feed want. They want the challenge to Patrick, that he did it. At no point in the trial, at any point, does he point a finger at Patrick as if he's an assailant. And he didn't do it in the closing either. He just goes to the credibility of some of the statements and how experts relied on Patrick, especially when he gets to the house, and especially when he says he sees Lindsay outside, and Lindsay says, "I tried to kill myself." And when asked, "Where are the kids?" Basement. So the challenge is the investigation, and specifically on that particular statement that Patrick attributes to Lindsay, because it's important. And I said this on Court TV this morning too. It's important because the experts, the Commonwealth experts, rely on those statements by Lindsay for her appreciation of right and wrong, having enough understanding to say the kids are in the basement, or I tried to kill myself. Then Reddington goes into the attack of the experts on the Commonwealth side, and not basically just challenging their credibility, challenging their opinions, trying to elevate the credibility of his experts, Zeisel and Resnick, but also going after the experts, Mack and others that the Commonwealth called. So it wasn't a lot that he did on that. It was pretty much blanket challenges to their opinions, and then going into the area that I would have focused on in this closing argument, which is Dr. Resnick. And in Reddington's closing, he goes and calls Resnick he's got the world record of examining psychiatric patients and psychosis. He's world renowned in this type of killing children. He wrote the article that's in the journal that even the Commonwealth experts have said is credible, and he even tried to admit it as a learned treatise, which is a hearsay exception in the rules of evidence about malingering, and articles on voices. That was the leading article on the research of psychosis, right? So I think this is where I would have really focused primarily in my closing arguments, is on Dr. Resnick, because of his credibility, because of his experience, because of all the things that he brings. And he hit it, don't get me wrong, but I think I would have brought Resnick into the closing arguments and weaved it in as I was hitting other different points. Goes to the timing of the interviews. So he talks about Zeisel, who was with Lindsay Clancy days after the homicide, and also Dr. Resnick, who interviewed Clancy 4 months after the homicide. And that the Commonwealth experts, they didn't interview Lindsay Clancy until years after. So he's in this area of who's more credible. And don't forget, as I led, this is the critical issue, because the prosecutor has to disprove the defense beyond a reasonable doubt. So have they disproven Resnick beyond a reasonable doubt? Have they disproven Zeisel beyond a reasonable doubt? I think that's most important in this case. That's my main takeaway. That's where I land on not criminally responsible, because I just don't believe that the prosecutor has disproven Resnick or Zeisel beyond a reasonable doubt. And that's where he was in this area. And he was talking about the burden of proof and proof beyond a reasonable doubt there. Basically continuing the argument with, look at all the records they got. They got her emails. They got her text messages. They got her college records. They did everything that they needed to do to look into this woman. And she's led a law-abiding life, that she's a nurse, a labor and delivery nurse, and just banging that drum about, Lindsay Clancy, law-abiding. Look at the history. Look at what we have in her emails and her college records, and her journals was another thing that he brought up. Physically holding the journals and showing she was tedious, and she was documenting, and she was involved, and she was active, and she was doing all the things that she needed to do during the treatment. Talked about the chicken nuggets, okay? Why are chicken nuggets important in this case? Well, when Patrick left, she was getting the kids ready to eat. And there's the, back and forth between the prosecutor and the defense about what she was doing when Patrick left. I mean, the prosecutor wants you to believe that she was calculated, and she was deliberate, and she was able to make food, and she was able to take the call from Patrick. And then, the defense is saying she didn't make chicken nuggets. I mean, there were only peppers and cucumbers on the plate. But again, this is where, again, I'm a little disappointed in the closing from Reddington, because it just felt like he was just jumping around at all these different areas, and at times talking about things that really weren't that critical, and making much more about, chicken nuggets and cucumbers and food than, the second element of the not criminally responsible, which is the appreciation and the capacity to understand right from wrong. Goes in, talks about Ian Whiffen, about how he somehow was one of the developers of Cellbrite, not really hitting the important parts about Whiffen, which is the fact that, in the watch and in the phone, we were able to get a timeline on the elevation of the steps. which is something that the prosecutor was able to talk about. And that really does go to what was happening at what time, when she took the phone call from Patrick, when she was elevating steps, and when she could have had opportunity to do the killings of the three kids. So Whiffin's name was brought up in his closing, but I didn't get much about why, that was important other than hearing it from the prosecutor later in her closing. Talking about Resnick again, talking about, the voices inside the heads and the research that he had done, 38% of 1,000, something about the voices, again, not really landing where we need to on right and wrong and appreciation and capacity. So that was about an hour. There was no break in between. Now, another thing, and I've never seen this before, like literally this is like first time, is that Reddington threw down quarters at the table, challenging the prosecutor on 3 points. And I think it was on the knots. I made some notes. On the knots, on why, like explaining why, like the prosecutor has to explain why, and then the third one's on Zeisel. But it was interesting, as the prosecutor was doing her closing argument, she was picking up the quarters and saying, well, took care of that one, took care of that one. It was interesting, the back and forth from an illustration perspective, that, Reddington's leaving these quarters on the table, and the prosecutor actually took the opportunity to pick them up and say, you want to talk about this one? Let's talk about the why. You want to talk about this one, the knots? Let's talk about the knots. You want to talk about Zeisel? Let's talk about it. And then she's putting her, the quarters into her pocket. Interesting, right? Also, when you compare the closing argument of Reddington to the closing argument of the prosecutor, it's definitely more logical. It's definitely more organized. It's definitely zeroing in on and focusing on the element that's most important, which is the element of appreciation, capacity to understand right from wrong. So she starts off by conceding the disease or defect. There's no doubt that she had disease or defect. So she's saying bipolar 1, bipolar 2. Again, it's not in dispute as to the disease or defect. The dispute and the fight and the deliberation, in my opinion, needs to be on that second prong of appreciation and capacity to understand right from wrong and conform conduct. So she's zeroing in there. She was talking initially about the lies. She's calling Lindsay Clancy's communication to the providers. She's lying about her homicidal ideations or suicidal ideations. And I think that this is a worthy conversation sort of globally about the fact that certainly when somebody goes into a provider and says that I have thoughts of killing others or myself, where does that process land? It typically lands with the Division of Child Protection Services coming in and taking adverse consequences and actions towards the reporter. So I don't necessarily think that Clancy was lying. I think that she was holding back a little bit in those, in those communications. And she did do what was expected of her otherwise. She was raising her hand. She was going to treatment. She was hospitalized from January 1 to 5. She was taking her meds. She was telling family members she wasn't right, including Patrick's mom and Patrick and her family. All right. So she was definitely, I wouldn't have characterized it as lying, but that's how the prosecutor starts off her closing, is attacking the statements to Tufts and Goodhart at McLean and MGH. talking about how it's back to what the prosecutor is trying to argue is that yeah, she was trying to get treatment and she was active in her treatment, but she was also goal directed and she was getting help. And so the prosecutor is trying to frame that as, well, Dr. Tufts only provided the 10 milligrams and then it was supposed to go up to 20 milligrams, and that was even enough for a kid. Denying psychosis, denying hearing the voices, or denying homicidal ideations, right? In the prosecutor's closing, she's making these arguments that she wasn't telling the providers about these homicidal ideations, that she was active in her treatment. She was keeping a detailed journal of the amounts of medications that she was taking and the effects that she was taking, and that the journaling stops on January 18th. So the defense wants you to believe that, she's getting progressively worse and even the journals are stopping. The prosecutor wants you to believe that she's active and she's knowledgeable and she's doing what she needs to do in her treatment. Then we get to January 24th. I mean, literally, like, that's, I think, the problem I had with Reddington is that didn't necessarily zero in on the 24th when the prosecutor definitely did zero in on the 24th. And if anybody sees any of my videos at the beginning on Court TV, I definitely have come around to the defense in this case. Initially, I was talking about the goal-directed behavior, the purposeful conduct, the calling of the restaurant, the understanding of how to order and what to order, and the Googling of the distance. Like, these are the things that the prosecutor next talks about in her closing that I thought was very, very powerful, because, the prosecutor wants the jury to be talking about January 24th and the things that Clancy was doing that make sense. And the defense wants to be about, all the history and the treatment and the lack of competent treatment. But the prosecutor definitely zeroes in on January 24th. Now, say what you want about the prosecutors. I have been very critical about the prosecutors. I have videos about the bows and the things and the ums and the ahas. And like, I have been very, very critical of the prosecutor throughout this entire trial. I think definitely you give the trial work inside to Reddington. I mean, Reddington crushed on cross, crushed on the attacking credibility of the providers. And I think that the prosecutor made tactical mistakes about the way that they presented, the witnesses that they presented in the direct. I thought they made a mistake with leaving the end with the forensic pathologist. And then also that incident that we had with Lindsay breaking down in front of the jury, and the jury those were tactical mistakes. I thought that they were out-lawyered by Reddington in the presentation of evidence. I think that they did have, the prosecutor, a very good closing argument, zeroing in on January 24th. And she started out by talking about the pediatrician, the doctor's appointment, where she's able to bring the child into the pediatrician in the morning of the 24th. Obviously, able to communicate, understanding, able to drive, able to talk. It was a doctor that did not identify any psychosis or problems cognitively on the date in question. Then the order at the 3V restaurant, right? And again, talking about the goal-directed behaviors and how she knew what she was doing and how she was going about this. She was able to talk about what she wanted. She was able to call the phone. She was the one that called the restaurant. She was able to remember what she wanted and what Patrick wanted. This is the Apple Maps, right? She, and this is part of the prosecutor's argument, was deliberate about getting the distance and the time between her house and the 3V restaurant, right? That they had called there before. She knew how far away it was, that there were alternatives to close restaurants or using DoorDash, about the call to the CVS about the Miralax and whether or not it was in stock, and just understanding the needs for availability and what Miralax was and what was ordered from the restaurant. Again, I still think that Resnick is reasonable doubt. Don't get me wrong. But I do think that the prosecutor did a good job in this area of trying to make all the arguments that they could on the date in question. The order to the V3, right? Calling it in, talking to the hostess. And then she gets into the timeline after Patrick leaves, which is 5:15 p.m. So this is where the prosecutor zeroed in on, and then going into what happened then. Goes downstairs, and this is where, we really don't know, but I guess the prosecutor's making argument from the timeline of the watch and the phone, and when the call came in from Patrick, and also when she went up the stairs, but basically making the argument here of the strangling and how it took time for the strangling. And this goes to the deliberate requirement of the first-degree murder, right? So if this jury does believe that she is not criminally responsible, and they're zeroing in on deliberation and atrocity and cruelty, well, this is the area that the prosecutor wants them to focus on, which is the cruelty of the strangulation and how the pressure is required and how long it takes and how the bands. And she gets into this dispute about the tying. And I know a lot of the feed and a lot of the comments are zeroed in on this because Patrick, in his testimony, said that he untied the actual bands around the kids' necks. Why is that important? That's important because untying and tying knots is very different than the actual manual strangulation of the kids. So there's still a dispute about tying. Something that I think Reddington could have made more of an issue about the knots and the tying and what Patrick said. But again, they have the evidence and they could ask for replays of Patrick's testimony to get back to this. And as I always say, as a defense attorney, you're trying to get advocates on that jury to be an advocate for you in the room. So I wonder how many advocates there's going to be in that room to try to sway a juror one way or the other if not everybody has consensus. And if they're not consensus on murder or the defense, it's a hung jury. And potentially we could be doing this again. Or maybe the prosecutor says, you know what? It wasn't what we thought. And maybe it is just hospital, and then resolving it that way if it's hung. But they have been arguing murder, obviously. And they have done it at this closing argument. And they're doing it in this part of the closing argument that I'm talking about right now, which is that timeline. So she talks about the timeline, the 5:15, the climbing of the steps between 5:33 and 5:38. Now, I think that is a very good argument for prosecutors to have that timeline of the steps. The prosecutor in Murdoch had the steps too, and that was when he went up into the house, and he was a busy bee, and he was doing all the steps more than any other part of the day. This is the Murdoch piece in this case, which is the going up 2 flights of steps between 5:33 and 5:38. So this timeline was being used by the prosecutor in this part of that closing argument. Then this is the weakest part of the prosecutor's argument on the Patrick statement. That Patrick gets there and goes up to the bedroom first and sees blood, and then goes out to the outside and finds Lindsay Clancy on the cold winter ground. And he says that she's not bleeding anymore. And he says, "What did you do?" And that Lindsay said, "I tried to kill myself." Okay, now that's the first statement that we have from Lindsay Clancy. And if believed, and again, this is being argued by the prosecutor and the experts, that is critical because it shows understanding right from wrong, and understands that she has the capacity to conform, right? So it's critical, but Reddington's making the argument that should not be believed. She didn't have the ability to talk, that it wasn't on the 911 calls. It was only moaning. So this is where the prosecutor's trying to say, hey, you could believe Patrick. You could believe Patrick on what Lindsay said, and then the experts are making argument that you should not only believe Patrick, but you should also take that into consideration for her ability to appreciate the difference between right and wrong. Then she goes into why, okay? Now, this is also known as motive. This is an area where prosecutors do not have to prove motive. It's not an element of murder. And oftentimes prosecutors want to show motive, like financial or whatnot. And if they try, be careful. Be careful. When you try to box yourself into motive, then it's just another area that, if not believed, then can go to reasonable doubt. So she says, why? And then goes into Resnick. Again, now the prosecutor's trying to use Dr. Resnick as an authority on the fact that most women kill their children, and it's a form of child abuse, not psychosis, not an affirmative defense or insanity, but most people kill because it's child abuse. And that Lindsay Clancy felt depressed, and she felt exhausted, and she felt done, and she felt damaged, and that she viewed her kids as the protective factor. And a lot of people are having problems with this argument here. It's in the area of motive. So basically the prosecutor saying, well, the kids were the protective factor. And if you follow that logic, well, maybe that's not why she actually killed herself, but why would you eliminate the protective factor? And that just really didn't land for me in this explanation of why. Because, I do believe that Lindsay had the capabilities and the knowledge and understanding as a labor and delivery nurse, that she had the capacity and knowledge where to slice, where to lacerate, and where the arteries were. And she didn't. I mean, it was superficial, at times. I mean, there was sutures that were necessary. But again, the testimony is from at least Patrick and the first responders that wasn't even bleeding at the time that law enforcement and first responders got to the scene. So I just don't think that I'm buying that she killed the kids because they were a protective factor. Then in the prosecutor's closing, she tried to make arguments about why you shouldn't believe the auditory hallucination of the man. The one time that Lindsay Clancy says that she heard a male voice command her to kill the kids and kill herself, right? This is what Dr. Resnick and Dr. Zeisel both rely on to come to the opinion of psychosis, which is the disease and defect, and that she was unable and did not have the capacity to appreciate right from wrong and conform her conduct. And this is where the prosecutor's now trying to argue, here's why you shouldn't believe her, that she even heard the voice. And the prosecutor started out by saying that, well, she immediately obeyed the voice. All right. She immediately followed the commands and tried to kill herself and also killed the kids. And then went into this comparison with Andrea Yates. Sorry, I called her Susan before. It's Andrea Yates, right? She goes into this, well, look at the Andrea Yates case. And that's where Resnick had some cross-examination in this area. I did post this on Instagram and TikTok about, well, yes, Yates was hearing the voices many times, and Yates was hospitalized 5 times. And the prosecutor wants this jury to believe that, look, you can't just hear it once and then follow the commands. So her first argument is, well, it's only once, and she followed the command and she never heard it after that. Also important in this area is that this was the only objection that Reddington made. And the judge told her to move on from Yates too, which was interesting here because that's important. As what was that ruling? What was that objection? He didn't even really make it. I wonder if Reddington made the objection after and then at least put it on the record. And what was the ruling? Because the judge just told the jury, told the prosecutor to move on without any real curative instruction or instruction. And what was the ruling there? Was that improper? It did come out in trial, but Reddington had an objection and the judge said move on. And it was in the area of Andrea Yates and the comparison between Yates and Clancy. Then the second part of you can't believe the voice and her theory and the expert's opinion about the auditory hallucination is that the voice has been told multiple times and about different in different ways. That Clancy has not been consistent, that she's given multiple accounts about what she heard at the hospital to the experts. And that's a reason of inconsistency. Because of the inconsistencies, well, you shouldn't believe what the experts are relying on. And then third, that the voice, these auditory hallucination and commands were vague, that they were vague. They weren't specific about how to do it, about the way to do it, whether it was strangulation and that you had to kill yourself by cutting yourself and jumping out a window. So 3 ways the prosecutor's trying to argue that the voice shouldn't be believed because she immediately obeyed, unlike Yates, that it was inconsistent and that it was vague. So then the prosecutor went and zeroed in on choices. So I think that's certainly the theme of the prosecutor's closing arguments today, was that Lindsay Clancy made choices. She chose the basement. She chose the mechanism of strangulation. She chose to use the exercise bands. She chose to kill herself in the ways that she did. And that's where, again, it was interesting to me that the prosecutor was picking up the quarter, saying, I'll take that one. You want to talk about the why? I'll take this one. And just an interesting dynamic between Reddington and the prosecutor in the closing arguments. Talking about the capability to actually kill oneself. This is something that the prosecutor was able to develop through the cross-examination and her experts. And basically saying that Lindsay Clancy couldn't get over the third prong of actually killing yourself. And that, we saw some testimony about the pills. We saw some testimony about cutting self, how it was horizontal in the meaty part of the arm. And again, that she was fighting and she was struggling with herself to actually kill, right? So again, not landing for me personally. I really wanted to hear much more about, the appreciation and capacity and the understanding between right and wrong. And I guess the prosecutor felt the need to try to explain the motive and explain like why she didn't actually kill herself. And she spent some time in that area right there in her closing. Then she goes to Zizel. And so the defense is arguing, that the prosecutor's theory was Zizel planted the voice, that Zizel gave Lindsay the phone to call Patrick, that Zizel was the one that was there first. And the prosecutor saying that's not our theory. We're not saying that Zizel planted this. This is something that the defense is trying to inject argument from. Now, in testimony, this did come up in one of the police officers' testimony, where Reddington was able, in his cross, to basically get that one of their theories, the law enforcement theories, was that Zizel planted the idea of this voice. So, it's not like Reddington just picked this out of thin air. There is testimony in the case that at least one of the police officers was articulating that there was a thought and theory internally by police that Zizel planted the idea of the auditory hallucinations. So then she basically goes into the law and is closing up here. The end of the closing goes into, again, that the burden is on them, that they had to disprove disease or defect, which they are not arguing. They're conceding this point, disease or defect, right? So that's a lot what Reddington focused on, but then goes into the next prong, whether or not knew right from wrong and can conform conduct. And then just getting back to the proof, and that the prosecutor has proven in their mind the first-degree murder of deliberation and the atrocity and the cruelty and the nature of the killing. That's for the first degree. And then disproven the mental disease or defect and the appreciation for right and wrong. And that's kind of where she ended. And they were both about an hour. Right after that, the judge came out, gave some instructions. It was about noon, about 12:30 at the time the closing arguments ended. And now the jury is going to deliberate. So again, I have recorded this. Hopefully I'll get this up before the jury comes back. But, the way I definitely land on not criminally responsible, just because of the burden of the prosecutor, that the prosecutor's burden was to disprove. And I don't think that they disproved Dr. Resnick specifically, and also Dr. Zizel. As far as where they land on first degree, second degree, or manslaughter, at first, they definitely can go not guilty there. And that's where I believe that, Reddington had to toe the line there between making arguments that, it's the red, white, and blue United States Constitution defense is we need to hold the burden for the prosecutor to prove the murder beyond a reasonable doubt. So there is a way for a creative jury in there to get to reasonable doubt on the murder, one, the second degree, or the manslaughter. There's enough. In fact, the judge gave the instruction on the manslaughter. They can come down there. They have an involuntary intoxication instruction in there about the medicines and how the medicine and the interaction and the effects could negate the mens rea of murder. They have that. They could also go not guilty. I mean, there's a fine line in there because the prosecutor still does have that initial burden beyond a reasonable doubt. So, I mean, that's where I fall. I don't think they're going to go not guilty all the way, because if they did, that's not guilty and go home. I do think they can get to that second part of the mental health defense here. And then if they cannot disprove it, if the prosecutor hasn't disproven the Dr. Resnick, the world-renowned doctor, I mean, that's where the reasonable doubt is, in my view here. That's where I think this jury should land. I think that that's what the evidence shows. And I think that, notwithstanding what I thought about Reddington's closing or how the prosecutor did, I think that that's where this falls. So let me know your comments below. Let me know your thoughts. Did I get it right? Did I get it wrong? And again, there's no right or wrong answer to this. This is about our criminal justice system. This is about a burden. And, at the very least, we need to take away from this case, whether or not you believe Lindsay Clancy did it, or that she was excused because of a disease or defect, or whether or not Patrick did it, honestly. This is about our medical system. And we just saw how the medical system needs to improve. And when somebody does raise their hand and say, I need help, or raise their hand and make a call to the suicide hotline, and whether or not somebody is willing to go into a hospital and get treatment from psychiatrists and things, we need to make sure that there are capable, experienced resources in place to make sure something like this never happens again. This is the conversation. This is my take. This is where I am going to continue to bang this drum moving forward as an advocate of attorney wellness and wellness in general. We need to do better when somebody asks for help. And unfortunately, it appears through the treatment of Lindsay Clancy that certainly much more could have been done. I appreciate everybody for all the comments and the support in all of the videos I've been posting, this one on Instagram, in TikTok, in YouTube, and Facebook. So where I post, certainly if you don't follow me, please smash that subscribe button, smash the follow button. And I do appreciate when I see people at least giving feedback and input on some of the things that we're covering on Core TV or some of the things that I'm talking about in my platforms. And really, it does go a long way to bring transparency and discussion so that we can do better as a society and improve things like the criminal justice system and the medical field when we can. Thank you again. Hold your loved ones tight. Let's do better. And let's all appreciate, have gratitude to what we have as we continue to discuss these very difficult cases in the press.